So I guess the really interesting thing to me, at least, about this whole situation with stun guns and how the 2016 Citino, and I always pronounce that wrong. I think I apologize to the plaintiff in that case, but the 2016 unanimous ruling really plays so much of a role here and gives such an example for how other Second Amendment cases or other areas of Second Amendment law can actually, where the Supreme Court can actually have that long-lasting impact. Because, you've seen Heller's obviously a landmark decision because it establishes, this individual right to keep and bear arms. But as mentioned at the opening of the show, there hasn't been a lot of systematic redoing of the nation's gun laws after Heller to this point. But here is the model of what that might look like if applied to other areas. So you have Heller, and then you have this second ruling in 2016 that's unanimous. Now, it'd probably be hard to get a unanimous ruling like that on more controversial topics of, in these other Second Amendment cases. But, it's an example of the Supreme Court sort of reasserting its initial ruling, telling Massachusetts that its interpretation of Heller was wrong. And then now you've had a lot of lower courts abide by that in these multiple different cases across the country, even if they don't like the Heller decision in the first place. So do you see that what you've done with these stun gun cases as an example for how other areas of Second Amendment case law could go?
I think that this is what we're going to see very soon, and probably by June. With the U.S. Supreme Court ruling in Bruin that there's going to be more guidance to the Supreme Court. And my personal view, to be honest, is it's not going to be as expansive a ruling as we might hope for. And what it's going to do is give more guidance to the lower courts. And there's going to be a similar situation, just like where I had to follow up with a number of lawsuits after the Citino decision. There's going to be a lot more work to do. But with that guidance that's going to come from the Supreme Court, there's going to be a lot of cases that are going to need to be filed, And I think the important thing is we try and figure out where winnable cases that are being done within the framework the Supreme Court has given, and push the envelope a little bit, but in a manner that the lower courts are going to be obligated to follow, in light of what guidance we're given in June.
Yeah. And it's interesting because I know there was some criticism of your effort to go after these stun gun laws initially. People thought this was a risky move that could backfire, right? If you had lost some of these cases, perhaps it would have, set Second Amendment protections back. So what was it in your calculation that made these cases worth trying in the federal courts?
Well, I think there was a number of reasons. I've always felt that, you have to just simply acknowledge that there is a political component to even the judiciary. There's a saying that, if you can't expect it to be seen on the front page of the papers, or if people would get mad by it, there's a good chance Supreme Court's not going to rule, in a way that's, just completely beyond the scope of what's politically palatable, at least to a segment of society, and with firearms, there's a very heated conversation with in this country, obviously, and that with the stun gun, that I felt that allows the court to rule on what arms are protected by the Second Amendment without delving into the issues of, say, mass shootings or, headline about gun violence. Rather, they can just simply back up and look at it analytically. Well, this is something that's obviously less dangerous than the handgun issue in Heller. And it definitely is an arm which can be used for self-defense, and there's simply not a lot of crime associated with it. So we can just simply look at this as a legal issue rather than something that has a lot of political baggage associated with it. So because it is a less than lethal weapon, I always felt that this makes for something that allows the courts to simply sort of look at it, a little bit more analytically rather than having to think about it in, with some sort of political component.
Interesting, yeah.
And yeah,
And so obviously now you weren't the lawyer in Sortino, the 2016 case, but I think your theory there probably goes to one of the reasons why that was a unanimous decision, right?
Yeah, I mean, I think, absolutely. I mean, I think we should take a look at the optics of and I myself do not know how to pronounce that last name, so bear with me. Jamie Saitano was a 4'11" homeless woman who had an abusive ex-boyfriend who she had been attacked by in the past. A friend of hers gave her a stun gun for the express purpose of defending herself from her ex-boyfriend. She had shortly after receiving it, she at one point brandished the stun gun when the ex-boyfriend came by, and he fled. Then shortly thereafter, she was in a parking lot of a grocery store, and the police caught her with it. And it served its a purpose there. No one was harmed, and just the undisputed facts of the case are stun guns are not something that really can be used in the way that they can, that maybe is associated with some other weapons, in terms of crime. So when it went before the Supreme Court, I think the optics were really good there. You have the exact type of person that needs a weapon. I mean, in Justice Alito's occurrence, I think he mentions that her domestic abuser was a foot taller than her. I mean, she needed a means of self-defense. She was 4'11", but she needed a means of self-defense in order to protect herself. And I mean, I think it was a very, it wasn't something that was so, astroturf. I mean, this was a very real person, a real situation. And I think that played to the outcome of the decision that all the justices were confronted with a person that was just simply trying to protect themselves, and a nonsensical law was in place that was criminalizing her ability to defend her own life, And so, yeah, I absolutely agree with your statement, Stephen.